Okay, once again, welcome. I want to thank you for joining us today. We have some more people signing in, but I think we're ready to go with this. Just so that you understand how this format will work today, this is audio only, so you will not be seeing a picture of me or Mark or anyone else. And at the end of the presentation by Mark, you're going to get a chance to ask questions. Well, during the presentations, if you put your mouse all the way to the bottom, there's a section where it says Q&A. You could point your mouse over that and click on it. Then you'll be able to type in any questions that you may have. I'll gather all the questions, and then at the end, when Mark's done, I will be asking him your question so that he could answer that. So once again, I want to thank you, and we really look forward to visiting with you at some point in person. I understand that some of you, because of what's going on, it's very difficult to get out. So we are really looking forward to seeing you face to face. If you have any questions at the end or any specific reason why you got on this webinar today, you're welcome to call us. Then we could have either a phone meeting with Mark Perkins, who's an attorney, or we could even do a Zoom or FaceTime meetings. So don't hesitate to ask us or give us a chance to talk with you about that. So without further ado, I'd like to invite Mark. And Mark, thanks so much for joining us. And I know you're very busy, and I am so glad that we've been working together for many, many years now. And look forward to hearing what the new rules going to be on the Secure Act and how it affects your nest egg. So thank you for being here. Go ahead, Mark.
Well, thanks, Randy, and thanks for inviting me. Again, my name is Mark Perkins. I'm an attorney. I've been practicing for about 30 years. I'm going to be talking about the Secure Act and how it affects everyone. And I'm going to talk a little bit about the old law and then the new law. So let's go ahead and jump right in. So just so you're aware, the House passed the bill for the Secure Act back in May of 2019. The Senate kind of sat on it for a while, and then finally on December 19th, they passed it. And the next day, Trump signed it into law. So it went into effect January 1st of this year. So at this point, that is the new law. Anybody who passes away from this year going forward, their IRAs or retirement accounts apply to this new law. So let's go into it. So the key changes of the new law is that your required minimum distribution, your RMDs, are no longer at 70.5; they're at 72. So that's good. There's no age cap on contributions to traditional IRAs. That's also good. Annuities now are permitted inside your 401k plans. Again, that's good. And allows penalty-free withdrawals up to $5,000 by each parent in the year of birth or adoption of a child. Of course, good. And then the bad thing, of course, is the now post-mortem requirement for the RMDs are over a 10-year period instead of what used to be a stretch. Stretch meaning that it used to be a beneficiary could inherit your retirement account and could stretch it over their whole life expectancy. Even if it was a one-year-old, the one-year-old could take the stretch option. Obviously, the guardian would, but could take the stretch option and could stretch it over like 90 years, kind of a thing, and pay a little bit of tax over time. Of course, our government needs money, and so they came up with this law basically throwing a lot of good things so that the main thing they wanted to get across was the bad thing. The bad thing was they need money now. So to get money now, they said, this stretching these things out, we're not getting our tax money. So they realized, hey, an easy way to get tax money now is to say it's a 10-year rule. They got to pull all the money out within 10 years. Now, there's some exceptions to that. We'll talk about that. But as a general rule, when someone inherits an IRA now, they have to withdraw all of it within 10 years. So we'll go into more detail here in a minute. So there's also just so you're aware, there are some situations where it's a 5-year rule, and we'll talk about that. It doesn't happen a lot, but it could happen. 10-year is now the normal, and does still happen where you can be still your life expectancy for some exceptions, and we'll talk about that in a minute. All right, let's go in the 5-year rule. So the 5-year rule only applies if you named a non-designated beneficiary as your beneficiary on your retirement account. So let's say you named a living trust, for example. Most living trusts do not meet the qualifications as a designated beneficiary. It has to really be drafted in a way that can meet that. So typical living trusts don't, and then it would be triggered as a 5-year rule rather than the new 10-year rule. So that means all assets have to be distributed within 5 years, and all out by 5 years. And really, got to remember, it starts the year following the person's death. So really, you're talking 6 calendar years, and depending on when the person died, it could be even later in the year, almost close to 7 years. So it depends again when the person passed away. So the typical rule, if it is a designated beneficiary and they don't meet the requirements of the exceptions, then it's a 10-year rule. And that, of course, replaces the traditional stretch, what used to be the stretch. So now all the money has to be distributed 10 years after the date of death. And again, it starts the first year following. So really, it's an 11-year rule. So it could stretch up to 11 years. And so that means that the beneficiary or beneficiaries can take all the money the first year. They could take 1/10 per year. They could take all the money the last year. They could take all the money in the middle of it. They could take 20% a year for the first 5 years. So it's totally up to the beneficiary how they take the money. And we'll talk about that a little more in a little bit. So let's talk about the eligible beneficiaries and how that works. There's 5 types. Surviving spouse, that hasn't changed. A surviving spouse then can roll over the IRA into their own IRA, or if they have no IRA, can create an IRA and roll it into that IRA and keep it tax deferred for the rest of their life. So their stretch continues. They can stretch it over their life expectancy, pay the tax a little bit at a time based on their life expectancy. That hasn't changed. Children under 18 can also do a stretch. So let's say you had a 1-year-old child and you named that 1-year-old child as your beneficiary on your IRA. That would stretch until they were 18, meaning it's paid over a life expectancy of a 1-year-old, which is a very nominal amount coming out every year, until they're 18. Once they hit 18, though, then it goes back to a normal 10-year stretch. And again, going with the 11th year calendar year, by the time they're 29, it would all have to be distributed. Disabled beneficiaries, we'll talk about that. I'll define that in a little bit, how it's defined on the IRS code. But basically, a disabled beneficiary can also continue to do a stretch, as well as chronically ill beneficiaries. So we'll talk about that in a little bit. Or someone that's less than 10 years younger than the IRA holder. So if you had a sibling that's less than 10 years younger than you, then they also can still do a stretch. Let's go back to minors now. So sometimes my clients will ask, well, Mark, I can just name my grandkids. I have a lot of grandkids that are, way under 18. I'll name them as my beneficiary. They could stretch until they're 18, right? No, actually they put a provision in there to prevent that from happening, because they figured a lot of people would do that. So they put a provision in so you can't do that. It only applies to children. And of course, we know most people with large IRAs have children that are over 18. So that's why they did that. They want to make sure that money comes out within 10 years. So the answer is no. If you're thinking ahead, say, I'm going to change my beneficiaries to my grandkids. That doesn't work. You cannot do, they do not get that. It's still a 10-year rule. So again, for children, when they hit age of majority, being 18, I put an asterisk there because in some states it's a little older, and they still actually haven't even defined it in some states. Typically it's 18, but you know, some states are now playing with that because of this and other things besides that, and defining age of majority being 21. Some states 25. So they're playing with that a little bit. Don't be surprised if that changes. And then I'm going to talk about for minors when you don't want them to inherit it too young, or if even you don't want them to inherit it as a 29-year-old. We'll talk about IRA trusts, or maybe they have a disability, or maybe they have, you know, special needs, or maybe that, you know, you're trying to protect it from them losing their special needs or their benefits, their government benefits, SSI or SSDI. So we're going to talk about IRA trusts. I also do a lot of IRA trusts for clients that have beneficiaries that have divorce potential or lawsuit potential. They're concerned about them getting sued or divorced, or bankruptcies, or again, they have bad spending habits, or they're, you know, not very responsible. So we'll talk about that too. So going back to disabled, what does disabled mean? So under the IRS code, section 72M7 says when you're unable to engage in any substantial gainful activity by reason of any medically determinable physical or mental impairment which can be expected to result in death or to be of long, continued, and indefinite duration. An individual shall not be considered to be disabled unless he furnishes proof of the existence thereof in such form and manner as the secretary may require. So there's kind of a mouthful there, but basically that's your definition. I should mention, by the way, if anybody would like a copy of the seminar, I can forward this to Randy, and Randy can send it out to you. So, you know, just let Randy know. I'll be sending this to Randy anyway. So anybody who wants a copy, just let Randy know, and he can email it to you. This way you don't have to write this down furiously right now or memorize it. If this is a concern, you know, we can send you that slide. So for chronically ill, there's three parts to it. One being unable to perform without substantial assistance from another individual at least two activities of daily living for an indefinite period reasonably expected to be lengthy in nature due to a loss of functional capacity, like, you know, bathing or eating or dressing, or, you know, something along those lines. Having a level of disability similar as determined under regulations prescribed by the Secretary in consultation with the Secretary of Health and Human Services to the level of disability described in Clause 1 above, or requiring substantial supervision to protect such individual from threats to health and safety due to severe cognitive impairment. So that's the definition of chronically ill. So let's get into a little math here. I know this isn't fun for some people, but I thought we'd cover it just to be, you know, so I'll give you an understanding. This is a very rudimentary, so all you guys have very good math. You'll find this very rudimentary, but I'm just kind of giving it as an example just to give, you know, something to talk about here. So let's just say that you had $1 million IRA, your beneficiary was 45. At a 7% growth, and we're going with the old rules, the old stretch, and we'll just do it over a 10-year period to make it apples to apples with the new 10-year rule. So the beneficiary then inherits, you know, at 45, starts taking out their RMD, you know, the required minimum distribution, and it shows you their life expectancy factor at a 45-year-old is 38.8 years, and so on. So, you know, that's how much they pull out based on the money. And so you can see every year what's coming out, so that by the 10th year, they're pulling out almost $51,000. So at that point, it's about 1.5 million. Okay, again, assuming there was no downside in the market, no way up swing, it's just a consistent 7%, which of course never happens, but, you know, just to give you an idea. Then with the new 10-year rule, same factors, 7% growth, Again, the same tax rates. If you're in the highest bracket at 37%, state tax at 5%. What if you waited? This is kind of showing you every year when you pull it out. So if you pull it out the first year versus the 10th year versus the 5th year or whatever, obviously you pull out the first year, you're paying less tax, but it doesn't get the same growth right away. So you're growing more tax deferred if you waited 10 years. If you could, get the 7% growth, obviously, because at that 7% growth tax deferred, you're getting at 2.1 million by the 10th year. And then, of course, your tax is higher. You're paying $884,000 in taxes, so you end up with a 1.2 million. So it's not exactly apples and apples, but gives you an idea. 1.2 versus the 1.5 if there was a stretch, kind of a thing. The other reason I like showing this slide really is to show that when someone might want to pull it out. If they're in a 37% bracket anyway, it's probably better just to wait till the 10th year. But if they're going up, and we'll talk about how that goes up in brackets, they might want to pull out a little earlier. So let's talk about how that works. So again, different brackets. If the person is in a lower bracket, let's say they're in a 24% bracket, then they're making, let's say, $100,000 a year, or something like that, and they can keep it, take money out to stay in the 24% bracket if they were single, or if they're married and they're making less than 200,000, let's say, then they could pull out enough to stay within that bracket, kind of a thing. So it's something you could play with, I guess, something you could talk to Randy about. It would be really for your beneficiaries, for them to let them know, hey, you would tell them, hey, when I die, make sure you go back to Randy. Randy's very familiar with these tax consequences. Go back to him and ask him, what's the best way to pull this out? When's the best way? What are the brackets? How does this work? Play with the numbers. Randy can crunch numbers for them to show them how to pull it out, when to pull it out, what's the best way, wait till the 10th year, take it 1/10 per year, take it all the first year. There's a lot of scenarios. So if you had a child that was 60 when you died, and then they could wait till they're 70 or 71, being that 11th calendar year, maybe they want to wait till the 71. Maybe by then they're in a very low bracket because they're retired and they're only in a 22% bracket. So you never know. There's always ways to play with this. Or maybe they want to wait till the last 2 or 3 years. They could stay in a low bracket for 2 or 3 years or something like that. So there's a lot of factors that go into this. It shouldn't, be decided offhand. It's really a case-by-case decision. So now I'm going to talk about IRA trusts and how they still are beneficial. Of course, they were much better when you had the stretch option, but now even without the stretch option, they still are beneficial. But let's just kind of go through it a little bit. So under the old law, you had really two choices, which is still today. You still have what's called a Conduit Trust or an Accumulation Trust. And I'll talk about both. And I'll talk about both under the old law, and then I'll talk about both under the new law. So when you're talking about a Conduit Trust under the old law, conduit meaning it just flows through the trust. One thing you have to be aware of, when someone dies, their trust becomes irrevocable. So a living trust, an IRA trust, any kind of trust, when someone dies, that trust becomes irrevocable and it gets its own tax ID number. And now that trust has to file its own tax return, and trust tax returns are filed as a 1041. So we file 1040s, but trust file 1041s. 1041s, if I go back to the slide, okay, 1041s had those same brackets, 10%, 12, 22, 24, and so on up to 37. The difference being it goes through those brackets very rapidly. And so you hit the 37% bracket when you're almost at $13,000 of income. So obviously a much different result, right? So you got to be aware of that. If you're going to go with a accumulation trust, which I'll talk about here in the next slide, that means it accumulates in the trust and you have to pay it at the trust tax rate. Any income above $13,000 gets taxed at 37%. A conduit trust is where it flows through. It goes from the trust. You know, you file the 1041, but on the 1041 it says there's a conduit, and it flowed through to the child's own name. So then it goes onto their own 1040. You file a K1 to show that, and now it goes onto their 1040, and now they can pay it in their income tax rate. And so that's the idea of a conduit trust. It flows through. Now, when the RMDs were 50,000, a conduit trust made a lot of sense because you know, most of that was getting taxed at 37%. So it would just be a conduit flow through, but it protected that beneficiary from lawsuits and divorces, and even against themselves. If they weren't very responsible, it would have a separate trustee. The trustee would make sure they don't take all the money all at once, and you know, things like that. The conduit trust now under the new rule is that all of it has to be flowed through within 10 years. So that could be bad in some situations. In some situations, it might not be too bad, but typically I'm finding now a lot of my clients don't really want to do a conduit trust anymore. When they're doing IRA trust now, it's more for the accumulation trust because they want the protection, and we kind of create a stretch for beneficiaries that aren't responsible. So let's talk about that. That's when we're talking about now accumulation trusts under the old law. Again, it would accumulate in that trust, and you have to pay the high tax rate. People didn't like that, and so I wasn't doing a lot of accumulation trusts then. I'm doing more accumulation trusts now, IRA accumulation trust, because now there's no longer a stretch IRA. So as you can see on the bottom of my slide, you hit the 37% bracket when you're over $12,950 of income. Of course, next year will be 13 something, and it's going to keep going like that, you know, up a little bit, but it's always going to be a low number, 13, 14 or so $1,000. So that's the downside. But the upside is if you have an irresponsible child, or a child that's on SSI I mentioned, or SSDI, you know, Social Security income and Social Security disability income, or they, you know, have a tendency to get sued a lot, or whatever, divorce a lot, whatever, any of those situations, and you want to make sure they don't spend it on something crazy or pull it out and, you know, all at once, then this makes a lot of sense. Then it's kind of like you don't care about the taxes so much because you want to preserve the principal. Yeah, so for 12 or 11 years, I should say, again, 11 calendar years, it's going to be paying into this trust. Again, let's say 50,000 a year on, you know, on the high side for a $2 million IRA, you know, 25,000 a year for $1 million IRA, and you're paying in that high bracket. But once it's all in there, now it's protected and can be distributed based on the trustee's discretion, based on when that beneficiary needs it, rather than whenever they want it, kind of a thing. So the big decision really is, you know, most non-spouse beneficiaries must withdraw the entire amount, again, within 10 years, or again, 11 years if you count calendar years. So the income tax, of course, will be accelerated because of that. It's no longer stretched over a lifetime. So if, you know, the question becomes, do we save taxes by going ahead and letting them, taking it out and paying their tax bracket? Or do we protect them from creditors, lawsuits, possible divorces, and so on? If number two is the answer, then you do need to do an IRA trust. And I would recommend an accumulation trust. Again, not the best for taxes, but it's great for protecting them against themselves. If that's not a concern, you got very responsible adult children or grandchildren or whatever, and you're not concerned about it, then I would say, then definitely name them as beneficiaries. Don't do the IRA trust, and let them figure out the stretch on their own when they can talk to someone like Randy, who could help them out every year on when to pull it out, and so on. So that's the end of my presentation, and now we can take questions.
All right, let's take a look at a few questions that we have received. One of the question mark is, what is the federal estate tax exemption amount, and how much, or what happens if you have more than that? What kind of tax rates do you pay?
Okay, so the federal estate tax exemption is about 11.5 million. But the bad news about Maryland is Maryland has its own state estate tax at 5 million. So still a pretty good number. 5 million is nothing to sneeze at. But if you have less than 5 million, nothing to worry about there, no estate tax problem. If you're over 5 million in Maryland, what we do is 2 separate trusts, one for each spouse. And thereby, by doing 2 separate trusts for husband and wife, you can do up to 10 million. But for a single person, of course, that wouldn't work. We'll have to do other things, and that gets a little more complicated than I have time to answer. But that's the general answer.
So when you say 11 million, that's for a husband and wife, not for a single person.
No, no, I'm saying federal. The federal exemption is 11.5 million. So if you were in Texas, which has no estate tax, then you would go by the federal exemption. Then you could have up to $22 million or 23. 11.5 times 11.5 plus 11.5 is $23 million. But in Maryland, the exemption is 5 million. So therefore, the most husband and wife can do is 10 million.
Excellent. This is actually, I guess, legal question about legal documents. What documents do you require or ask people to have as they're looking at their retirement years?
Well, for sure, you want at least a will, a power of attorney for healthcare, advanced directives like a living will, which is basically a document saying it's okay to pull the plug so you're not on a machine forever. A power of attorney for finance, who can sign your name if you become mentally disabled, which is very important. People don't realize we're about 4 or 5 times more likely to become mentally disabled any given year than we are to die. So just keep that in mind. A lot more people, especially as we're getting older and older, and medical keeps us alive longer, and medicine and so on. A lot more people going into dementia, Alzheimer's, strokes. So you have a lot of people that are mentally becoming incompetent, where power of attorney is much more important now than it ever used to be. So keep that in mind. So at least those documents, if nothing else. Now, if you have, especially if you have an estate tax problem, meaning 5 million plus, you definitely want to do a trust. If you're under that, then you still might want to do a trust depending on your assets. If you have real estate and you want to avoid probate, that kind of thing. If you want to or protect beneficiaries against themselves, or then you want to do an IRA trust. So there's a lot of documents you could do, but I would say at least the basics.
Okay. Another question came in is, are existing trusts with IRAs grandfathered in under the old rules?
If you died in 2019, yes. Since you're asking the question, I'm guessing the answer is no.
Okay. And the last question is, can you explain the difference between having a will versus trust? What is better? Which one is better?
So it's not necessarily better. It's more of a question of, like, I describe a will as like being, so they're both vehicles, right? They're both estate planning vehicles. The will would be like a estate planning bicycle, and the trust would be like an estate planning car. The will get you there eventually, but you might not like the results of the way it got there, right? So if it happens that you're taking that bicycle and there's a rainstorm or a hailstorm or snow, sleet, whatever, the bike's not going to be a very good vehicle to take. So just to keep in mind, all wills have to be filed in probate court within 30 days of the person's death. So if you want to avoid probate, and most people do want to avoid probate, then just keep that in mind. Wills have to be filed in probate, and all your assets must go through probate then by the will, to make sure that all the probatable assets go through according to will. And probate cannot be less than 6 months by law. So typical probates are 9 months to a year. If there's no problems at all, 9 months to a year is very normal. It can last decades. I mean, it's very uncommon, but you got Elvis Presley, Marilyn Monroe, John Wayne, all more than 10 years. I mean, keep in mind, John Wayne died in 1979. His probate ended in 1991. You got Prince now, Aretha Franklin, all these celebrities now going through probate that, again, those will probably all be 10-year probate. So you can't have a very long probate, but a typical probate is about a year.
Okay,
So
the
if you
last
do-
question.
Well, I should just finish up. I'm sorry, Randy.
Okay, go ahead.
Just to finish up then, is that, yeah, so if you do a living trust, you avoid all that. So if that's something you want to avoid, yeah, living trust solves all those problems. I'm sorry, go ahead.
No, not at all. The last question is, where a man and wife are trustees in a revocable trust, does it change to irrevocable when one dies or when both die?
Depends. So if you do a joint trust or you do a single trust, so a husband and wife, he can have his own trust and she can have her own trust. They both could still be co-trustees and co-beneficiaries of each other's trust, but when he dies, his trust becomes irrevocable. She's still a trustee and beneficiary of it, and she's still a trustee and beneficiary of her own trust, but her trust is revocable still because she's alive. His trust is irrevocable, so therefore it cannot be changed, but she could take out, well, depending on what it says, but typically she could take out whatever she wants because typically the spouse is the trustee and beneficiary. She could spend it all the next day if she wanted to on a typical husband and wife kind of two separate trusts. Now, on a joint trust, depending on what the joint trust says, if the joint trust says if one of them dies, it becomes irrevocable and the survivor can't change it, then it's irrevocable. If it says, which is typical again, typically the people will say, I want to make it so that it's changeable the first death so my surviving spouse can still amend it and it doesn't become irrevocable until the second death. So again, depending on the trust you do and how you draft it.
Okay, well, those are the last questions that we have. I want to thank everyone for being with us. And Mark, thank you. You've been a great resource for us, and thank you for joining us today. If you have any questions about any other questions on trust or anything to do with the estate planning, please contact me. And then if you need to reach out to Mark, we could set up a Zoom or FaceTime type of meetings. So we look forward to doing that. Just to let you know that we are scheduled already for the next webinar. It's going to be on Tuesday, the July 21st. And at that time, we're going to go over how effectively transfer your wealth to your kids, grandkids, and any other beneficiaries in a tax-efficient manner. So please look forward to that date and put it in your calendar to join us at 12 o'clock. And once again, thank you for being with us, and God bless.